A contract breach is when one party fails to meet their end of an obligation that the two parties agreed to and put into writing. So when a contract is signed between two parties, and these parties are basically agreeing to terms to fulfill the obligations that they have with each other. When the agreement is not met by one of the parties or they don't perform as they're supposed to, this can be considered a breach of contract. Now, there are different damages that can be looked at, and that would be compensatory damages, liquidated damages, and nominal damages. Compensatory damages, that's a loss of expected or actual damages that a party was expected to gain as a profit, but instead lost. Compensatory damages are damages that compensate a party for their loss. Liquidated damages, those are provisions placed within a contract that specify the amount that will be lost if the contract is breached. This is done because the actual calculations are too difficult to determine. The damages that are present must represent the actual losses suffered or come close to representing these for action to be taken. There's also nominal damages. That's a breach of contract where it's evident that there was a contract breach. However, the amounts awarded for the breach, those would be small amounts. Remedies in court, the court can order parties involved to comply with the terms of the contract, or they can rescind the contract as if it never existed, or they can order the party to pay restitution for the value of the services received. Complex licensing. Complex licensing is an agreement in which the business of the licensing agreement, scope of the agreement, and timelines are not clear. Some areas to consider regarding a complex license agreement: there are multiple companies involved, different assets involved. You got to look at what the rights reserved, what are the potential tax issues, focus on how specific terms within the agreement are defined, understand the term product and what is being referred to when this verbiage is mentioned. Looking at the scope, what is being licensed from one company to another, is sub-licensing included, and the obligations, what is each company responsible for. Now, the contract process would include drafting, negotiating, executing, and closing out. The drafting is basically who's involved, the best type of contract for the situation, and understanding and agreeing to the terms. Negotiating would be reviewing the terms of the contract, understanding the legalities of the contract, and both sides coming to an agreement on the contract specifics. Executing is basically finalizing and executing based off of all parties' agreements to the contract. Closing out, once the contract is concluded, all payments have been handled and all terms of the contract have been met, this would be considered a closeout of the contract. Now, the complexity in the process, that's when expectations are not clearly defined. Processes and the scope of the projects is not reasonable. Maybe the budget is higher than expected. Resources are not readily available. There's timing of the project is not suffice between the two parties. And there's also the companies usually want to get into contracts and within the organization because contracts bind the agreement between the parties involved, making it more likely that the organization will choose to go this route. In addition, legal ramifications are in place if there is a breach, so this is more enticing knowing that the investment is secured.